Well, hello, everyone, and welcome to this Federalist Society virtual event. I'm Caroline Bryant, and I'm Associate Director of Practice Groups with the Federalist Society. Today, we're excited to host the SEC and Cryptocurrency, featuring Rachel Barnett, William McLucas, and Brian Richman. Professor Chris Brummer will hopefully joining us in a bit. Our moderator today is Pat Daugherty. Pat is a partner at Foley and Lardner, where he directs the corporate, M&A, finance, financial regulatory, and fintech practice devoted to capital formation, innovation, and return of and on investment. If you'd like to learn more about today's speakers, their full bios can be viewed on our website, fedsoc.org. After our speakers give their opening remarks, we will turn to you, the audience, for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we will do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our guest speakers, not the Federalist Society. With that, moderator, thank you for joining us today, and the floor is yours.
Thanks very much. This is Pat Daugherty coming to you from Chicago, and I see Chris Brummer has joined our panel. Thank you, Chris. We're actually going to lead off with you, and more of an introduction here. Chris Brummer is the Agnes Williams Sesquicentennial Professor of Financial Technology at Georgetown Law and the Faculty Director of the Georgetown Institute of International Economic Law. He has a vast number of other credentials and involvements. For example, he runs DC FinTech Week pretty much all year round. His other volunteer work includes the Biden-Harris transition team, where he fended off several appointments of himself. And he's the director of Fannie Mae. I'm omitting other things because we only have an hour. But in my view, Chris is actually the foremost scholar on digital assets in the world. I'm really glad that you would give us your time, because I know it's a scarce commodity. Asked you if you would introduce the program by giving us a rundown about what the SEC's been doing with cryptocurrency lately. Just a rundown could take forever, but
maybe the best way to start is let's call it a little bit of a philosophical sort of approach, and I'm sure this is something that, particularly as lawyers, we find rather interesting. And by the way, thank you so much for giving me the opportunity to participate alongside Rachel and all these great folks. I really admire the work you've done, and it's just a pleasure to be here. So I quite ironically, I actually had a room full of Indonesian financial regulators talking to them maybe about 4 or 5 days ago. Their entire leadership was in town over in Washington, and part of it, their initial question was, okay, look, we understand sort of more or less the different regulatory agencies in the United States, but what is it about the SEC that we keep hearing about that makes it something that we need to pay particular attention to when it comes to us drafting our own legislation in Indonesia for crypto assets? And I said, well, I think one of the most important things that I think even we here in the United States are trying to grapple with is not just the agency in terms of its oversight and how it's, choosing to interpret some of its, the core legislative rules relating to what is a security and what is not a security, but it's really this fundamental question about, how is it going to pursue its agenda with the tools that are in its toolbox? And I said that that's kind of the first question, because it drives both what sort of rules or policy are eventually made, and then it also drives the inevitable political environment in which the agency is operating. And oddly enough, it's not every day that something as technocratic or boring as the SEC becomes a matter of presidential politics, but it does happen from time to time, and that's certainly a cycle in which that particular toolbox is attracting attention beyond just the immediate regulatory sphere. So I think that when you look at the SEC and what it's chosen to do when it comes to crypto assets is to sort of really define what are cryptocurrencies as effectively being securities, and using the enforcement mechanism as the primary tool by which to prove the point. So as opposed to, say, engaging in certain forms of rulemaking, or notice and comment rulemaking, or even as the predecessing Chair Clayton had started to do with some instances of guidance for the cryptocurrency industry. The tool of choice, the weapon of choice, has been through litigation, and that's probably what many of your viewers right now are most familiar with when it comes to the SEC as an enforcement agency. So whether or not against Ripple or against the more high profile cases like Ripple or Coinbase, you've seen an attempt to establish the regulatory perimeter of the agency through enforcement actions, sometimes targeting the infrastructure provider itself in the sense of Coinbase, and then sort of derivatively listing out all these other cryptocurrency assets and sort of deeming them to be securities, and then hoping to sort of either attract or to draw those other entities into the fray, and to sort of handle the issue in a large sort of omnibus level litigation process. Now, that is, it's a very high stakes way of going about its job as a regulatory agency. If you win big, and if you lose, then you lose big. Regardless, it is a process that does take a lot of time. It is a process with certain immediate wins because you inject uncertainty into the process, into the regulatory space immediately. So even if you end up being wrong, the rest of the industry actually has to pay attention to the fact that there is litigation in that space. And so it does have the effect of immediately sort of slowing down things in the space. So if that is a goal of the agency, litigation is one of the more effective ways to do it. If you end up being wrong, it does, however, mean that you practice that tool and pointed it in areas that are actually outside of your mandate. But it is a way to slow things down, regardless as to whether or not they fall directly in your mandate or not. We can get into any of those cases, but I think that that's the, if you want to talk about like what is the SEC doing, the SEC is suing people. Yes. and the SEC is suing people with the objective of using courts as the primary sort of tool for laying out U.S. securities law.
Chris, one of your more famous pieces of scholarship is regulation by enforcement, which I mentions because viewers might want to Google that one and read it if they have it. My students all read it. And you're discussing many of the factors that you and your co-authors of that article discuss at length in that article, which is a very influential one. There are some things that the SEC has done that might be considered pro-industry. I'll point to one recent one, which is the exchange-traded products that have been approved. First, the Bitcoin products, and now very recently, at least almost approved in concept, the ETH ETPs as well. What's your view about that? Are they sort of reversing course away from litigation and enforcement, or what are the factors that went into play in approving those exchange traded products?
Well, I mean, for the Bitcoin ETF, it's when you start to lose, then you have to obviously, take a step back and ultimately, as I think Chair Gensler himself said, you have to recognize what the courts have said, and when the courts speak, you have to abide by the law, not the law of the regulatory agency, but by the law of the courts.
Yeah, you're referring specifically to the Grayscale case in the DC Circuit where they got clobbered.
Where they that is a technical term, sir. And that is one of the dangers, right? You either win or you lose, and sometimes court rulings are very blunt instruments, and they don't necessarily have a lot of precision to them. And so when not accompanied by specific rulemaking, losses can not only pile up to create sort of tricky precedent, but even if you are thinking about the welfare of your agency, if you lose the wrong way, then your agency can end up emasculated.
And it's certainly a loss of prestige, right?
And certainly a loss of fear. If people start to win, then other people get a little bit more backbone, and they start to push back as well.
We're going to turn to that shortly here. In fact, I'm going to ease into it now, Chris, with your permission. I'm going to introduce Bill McLucas next. I'm sure you all know one another well, but Bill is a former director of the SEC Division of Enforcement and the longtime head of the securities practice of WilmerHale from his home in DC. Bill has handled more enforcement matters than I could possibly recount. But crypto is new, relatively speaking. It's only, since the Satoshi white paper, I will say, right? So most of your work preceded the crypto era, Bill. Mine too. But what are the key differences in how to defend a crypto investigation during Chair Gensler's tenure versus defending any other kind of case that the SEC might choose to investigate now or in the past? Speak to that.
Yeah, Pat, it's interesting because the SEC, as you know, does a whole array of different kinds of cases, from accounting fraud to disclosure to insider trading to market manipulation. And crypto, unlike a lot of other kinds of issues that you're faced with as a defense counsel, those cases, there's an off-ramp. I can perhaps settle a disclosure case with a reporting violation as opposed to a fraud charge. I can perhaps settle a trading case with a non-scienter based provision of the 33 Act rather than 10b-5. Excuse me. Crypto cases, it's a zero-sum game. There's no off-ramp. I can't navigate, most clients can't navigate to a disposition that's tolerable and lets them live another day. Why? Because it's Section 5, and that's you're either registered or you're not registered. And that ultimate consequence changes the thinking going into one of these cases from the get-go. The other aspect of crypto cases, for everybody who's a defense lawyer and who deals with these issues, the disposition of the staff, and first of all, the staff, their job is to bring cases. They're not looking to spend a year or 6 months of their life and then say, you're really a good market participant, go and, you haven't done anything wrong, God bless you. So in crypto, it's even a little different because you're almost guilty, at least you get the sense you're guilty of a status offense from day one. You're guilty of being involved in crypto, and now we have to figure out how we build that and get to the case. Now, that may be heard to be a bit of an overstatement, but I think it's the sense that one gets. in the crypto arena when you're involved in these kinds of cases. So that means, there's a lot of work to be done, a lot of documents. So these subpoenas are collecting information, but at the end of the day, you and your client are thinking about where do we go here? Do we have a viable option? And to pick up Chris's comments, for many firms, it's going to be make a decision to cut your losses, go out of business and move on, or we're going to fight because there's no reasonable alternative here that's not existential. I'm either left dead by the side of the road, or I'm going to fight until I know I have no other options. And I think that's part of the challenge in representing somebody. Now, the theory, as everybody knows, that is the centerpiece is Howey and Section 5 and a 1946 Supreme Court decision that dealt with orange groves, which is a little odd. Now, the government rightfully will say, look, a security is a security, fraud is fraud. It's a simple equation. And that proves a little too much, given that in 1946, no one envisioned cell phones, the internet, or much less 20 years ago, this idea of something called crypto. But that's where we are. And I think in picking up one of the points Chris made, the approach by the government, that is, should I figure out, is there a regulatory solution here, or am I going to use enforcement and that's it? Remember, 2017, the market was, I don't know, it was $100 billion. Today, it's a $2.3 trillion market. The reality is it's here. And I know there are concerns about crypto, some of the issues about money laundering, tax evasion, terrorism. Those are all legitimate governmental concerns. The issue, though, is what do we do?
Yeah.
And I think the blunt instrument of, well, we're just going to do it by enforcement, I don't think it's working, in the sense that it's too much like wackadoodle. You can't hit them all, and it's here to stay. And now the question is, where do we go? The suggestion, come in and register, I think, politely was not the most credible suggestion by the government, because those who have tried have been met with less than a constructive dialogue. The dissent by Commissioner Peirce and Commissioner Ueda in the shapeshift case on March 4th of this year sort of articulates the anomaly that the commission has created by saying, come in and register. But if you come in to register, they say, well, what do you want to register? And you say, I'd like to register these things. And they say, well, what's your securities? And you say, well, I need some help in figuring that out. And they say, well, we can't help you. Go talk to your lawyer. And the lawyer says, well, I've looked at them. And so anyway,
we don't give legal advice. Yes.
Yeah, I think that we're at a point where you may begin to see some different approach by the SEC. You may not. The chairman's made no bones about his views of crypto. And, I don't know whether we'll shift to a different regime and an approach to deal with them from a regulatory standpoint or not. But thus far, it's all been enforcement.
Let me ask you a couple follow-ups, if I might. So you and Chris are Washington insiders. I'm out here in flyover land. That's Marina City behind me. But so to an outsider like me, it looks very much like the agency's enforcement program is being directed by the chairman here. And it is a Securities and Exchange Commission. It's not a Securities and Exchange Agency. Nevertheless, he does seem to have a very powerful and direct control over the enforcement program, at least in crypto, right? So I'm going to ask, is that a correct perception or not? And if it's true, how does that affect your defense strategy and tactics if you come under scrutiny?
So certainly the perception is consistent among the defense bar and the lawyers who deal in this area that the chairman's involvement in the enforcement side of this and the whole agenda on crypto is much more intensive and direct than perhaps in any other area. That compares, I would suggest to you, I served under 5 chairmen, 2 of them as the director, and they were all, their influence on policy and programs and enforcement was all very substantial. On the other hand, they saw the product after the cake was reasonably baked and presented for a recommendation. Now, there was policy influence. Clearly, the direction of the agency was dictated by the chairman and the commissioners, but rarely did I have a situation where the chairman or an individual commissioner was knee deep or waist deep in the enforcement process or investigation itself. I do think that the impression that I have right now is that that's not the case in crypto. And what that means is when you get to critical points in an investigation or a negotiation, what you're generally hearing from the staff, you pretty much have to assume is coming from the chairman, who is likely to be the ultimate word on those issues, because it's a 3-2 generally split on the commission. And when the chairman takes a position, one can assume that that's where the majority of the commissioners is going to go. That is different. And is it healthy? Is it? I don't know. It just is the way it is, and it's the reality we have right now.
Let me ask you another, and then I'm going to come back to Chris for a minute. So suppose you've got an investigation underway now. You know, commissioners turn over. No one's got a lifetime appointment. This is not Article 3. Do you hope for possible change on the commission before your case is over? Or is that not really a factor? Do you just go about your business defending the case, negotiating, and trying to get the best deal you can for your client?
I mean, I think everybody evaluates that, particularly the clients. When I'm asked, I, give my best assessment, but the reality is my crystal ball has always been really very, very iffy. And I'm so bad at predicting these things that you end up saying to the client, look, I can give you my sense of where it's going and what might be in 3 months, 6 months, but those are decisions that are really, really hard to land on anything with a lot of confidence, because particularly in this area. And one of the things that I think we all have to keep in mind in this area is uniquely, I think this is susceptible of the kind of scandal or explosion in one matter with one bad actor that can upset the world and the dynamic in a way that adds a variable that will affect everybody else in the industry. And if we had, I believe, a regulatory regime, tough as that might be, it would reduce that variability risk and provide more predictability to people that are in the crypto industry in a way that would be healthy.
Yeah, there were another explosion could come along, although the first thing that came to my mind when you mentioned that was the explosion named Sam Bankman-Fried at FTX. What my sense is that really changed up what was going on inside the building at the SEC, and that it was that which caused them to really take a much harder line. And I wonder whether you share that perception. And
no, I think you're right. I think you're right. And it's it's from when you're in the government and you're looking at something like that and you haven't been proactive and gone out and been very aggressive, and something goes wrong, you're going to get blamed. And I can understand it. I actually am surprised at the recovery from the post-Blankman era. Yeah. And I would have expected it to linger longer, but so.
Well, maybe this too shall pass. Chris, I'm back to you for
Can I just jump in on one or two
Yes.
sort of interesting sort of Tignet? Sort of, you know, about a year and a half ago, it was you know, I had the sort of privilege to actually give a lecture to the entire crypto enforcement team, right? And they called it, and they called me in.
Meaning the SEC crypto enforcement team. Yes, yes.
That's right. That's right. I meant the SEC. I don't know what I said. Sorry.
Yes,
yes.
Yes.
Yeah, for the SEC. And it was you know, I'm over at Georgetown, so I'm only, you know, a couple blocks away, you know, just stroll on over to the SEC and you know, knock on the SEC door, and you come in. And you know, the first impression that I had was when I saw the crypto enforcement team was, wow, there are a whole lot of you guys, was the first sort of impression that there were certainly lots of different staff resources and agency resources that were kind of committed. You know, which is on the one hand, it's a sign of how serious the SEC takes cryptocurrency enforcement. Size doesn't always matter, you know, like as I'm, you know, this is a field where expertise is really important. And, you know, there's a certain amount of judgment that's required to know when to pursue cases and how to pursue cases. And obviously you can end up sort of tripping over yourself if you don't have the right kinds of people. But I certainly did get the impression that, you know, there are lots of people who are, who have been seconded, you know, who are not necessarily lifers, who are there. And my, you know, impression was just sort of talking to them that there are a couple of things. Number one, you don't, you know, you're a litigator in order to litigate, is, you know, to echo Bill's sort of earlier comments. I did get the sense though that you don't litigate to lose either, you know. And I do think that to the extent to which the other parts of the building aren't actively sort of doing their job in the space, so, you know, the rule writing parts, then it does put additional pressure on then the enforcement team, because now they're not just enforcing things, but they're effectively, you know, quasi rule writing or rulemaking at the same time. And that can at times, you know, be a little bit more frustrating. And I did get the sense that, you know, a couple of people on the, even in the enforcement staff, were very well aware of the fact that they're being asked to do more in a way that isn't necessarily easy. And so I would say that I wouldn't view them as a monolith. And I do think that there are enforcement staffers who are sitting there, and, you know, I made a quasi joke, but not really a joke, to them. And I did say to them, I said, you know, I feel sorry for you guys. And they looked at me like, why are you feeling sorry for us? And, you know, looked out at them all, and I said, yeah, because, you know, not everybody's doing everything, which means you guys have to do so much more. And I'm sure that's really fun when you go in front of a judge. And there were people in the audience who were shaking their head in agreement with me. So, you know, I don't think they're a monolithic group. And I do know that, you know, when you lose a case, now this was actually, it was a while back, I actually went there, but it was shortly after the Ripple ruling. You know, but there are high stakes, as I said, and no one likes to lose. And when you do lose, or you feel as if you've had the stakes set against you a little bit, then that can be a little bit frustrating. I think that the agency is ultimately, you know, I ask, and this is more of a question than anything, if you do have a chair who does sort of taint the entire industry one way, regularly and commonly, you know, I ask myself at times, you know, how does that impact the enforcement posture? How does that impact how you go about doing your job as a litigator? You know, especially in a world where there are no off ramps, you know. And I think that I'd be curious to maybe get your view from the outside.
Well,
from the outside of DC of the DC bubble.
Yes. That's very good, Professor, but I'll ask questions here.
Ha!
And
No.
I teach too, but not as well
You
as
do,
he.
you do.
But
Yeah.
no, really though, I will ask you this, because chairmen come and go too. I took a look and I saw that Bill Douglas was gone, Jerome Frank, they're not to be found. They're gone. Some of them are long gone. So, we have an election coming up. Uh, if and sometimes there's turnover, even if the same party wins. So President Biden wins re-election, with the SEC, and comment on that. And also, suppose the other guy wins, what happens then? I mean, does Commissioner Peirce become Chairman Peirce? I mean, what other names are being kicked around besides yours? But
Yeah, I admire Esther Peirce, immensely.
Yeah.
I think she's great. Certainly, look, if Trump wins, then we will have a new SEC chair. That SEC chair would presumably be a very big difference in terms of the posture taken. I mean, Trump has made crypto now part of his election strategy. If he was to win, presumably, then those promises would be translated into the posture of the regulatory agency. So you would have certainly a change in policy. Now, again, and it's kind of interesting, there's a difference between a change in policy and then what happens with the litigation that's already outstanding, right? So, if you already have the litigation moving, it's a little bit of a difference in terms of what the administration and what a new chair would want to do. And, revisiting what are the options on the table with that litigation versus prospectively looking at what the policy towards cryptocurrencies, should be.
Yeah.
But it would be a sea change, presumably, in crypto if Trump wins. I do think that, if Biden wins, one would normally expect there to be a change to SEC leadership, and it would be hard to imagine a chair who is sort of staked more of his or her reputation as being against a particular industry as much as Gensler has. So you would think that in the future, even in a Democratic administration, that you would have an SEC leader who is not at least as obviously against the industry as you have right now. There are all kinds of interesting questions. The SEC chairmanship, no matter who has it, I think a lot of people would agree is a very tough job to have right now. It is an agency, not just in terms of crypto, but in other areas. It is a highly politicized agency right now, and at least it's viewed as such. And as a result, whoever wants to be in charge of that agency would be subject to a very broad set of political scrutiny, right? And pain, frankly, in the confirmation process, likely, and that could certainly make people a little bit wary of taking the job. And then there's a question of, well, does that then mean that you have a little bit of a longer period in which the leadership remains, just because it's difficult to replace?
That could happen. There's certainly strong views on this on both sides in the Senate, for example. So I appreciate that. I want to turn over the program now actually to Brian Richman. And first, an introduction. Brian, we're just meeting, but you're from Eugene Scalia's team at Gibson Dunn, and he told me that you're an ace. And I've got to say, Eugene Scalia has sued the SEC several times and won. And other agencies as well. So if he says you're an ace, then you're all aces with me. Yeah, you come to us from Dallas, but before that, you did some time at Goldman Sachs, and you came out of a law school in New Haven, Connecticut, and up to college at Cornell, where I hold forth in the fall. I am delighted that you would join us. Your topic is, suing the SEC, because if you are in the industry now and you're not content to wait to be sued, or maybe some rule's been adopted that doesn't seem to really have much of a basis in statutory text, and you fear that it's going to really cramp your business or put you out of business, you might think about suing the SEC. Well, there are several litigants who've done exactly that. Some of them are your clients. So would you please address for us, and by the way, you can hire Bill McLucas if you get sued, and you could hardly do better than that. But if you want to get ahead of the game, what do you do? Talk about suing the SEC, would you please?
Sure. Thank you, Pat. Suing the SEC is what we do. We do that very frequently, often successfully. There are a number of ways to bring this issue up before the courts offensively, and I'll focus on two here today. So one you mentioned, which is the rulemaking context. Yes, the commission has not come out directly with rules that are as clear as people would probably like in the crypto area, but still there are commission rules that touch on crypto. And the commission's refusal, I think, to take positions on crypto issues, to leave things vague, to not resolve problems in the space, legal questions, actually creates vulnerabilities on the rulemaking front. So what's unique about the SEC is that they, like all agencies, are governed by the Administrative Procedure Act, which requires them to consider all important aspects of a problem during a rulemaking. But under the SEC's organic statutes, the SEC actually has a special statutory obligation to conduct an economic analysis of its rules, to dig in as to will the rules promote efficiency, competition, and capital formation. And that's just not mentioning those topics. The commission must actually analyze it. The courts have said, quote, as best as it can. And I think the commission's position on crypto has created some issues for it. So I'll give you one example. There's pending litigation, both on the crypto side and on the non-crypto side, and we're involved on the non-crypto side, on the SEC's attempt to redefine what is a securities dealer. So the SEC comes out with this rule, a very, very broad definition of who is a securities dealer, who has to register with the SEC. What's interesting from, I think, our perspective of this conversation is the commission says, well, this applies to crypto, provided you're dealing with crypto that are securities. But here's the issue that the commission has. They refuse to take a position on really, well, what is a security? So you have the agency who has this obligation to conduct a thorough economic analysis saying, well, we're going to apply this definition in the crypto world, but then it refuses to tell you, okay, well, how big is it? Who's covered by it, right? What firms are covered? What crypto is covered? And you really get this economic analysis that is pretty cursory and doesn't really dig into the issues at all. That's certainly been teed up in pending litigation, and we'll see where that goes. But I do think that rulemaking context is a very straightforward way to start getting these issues before courts.
Well, their agency officials have been heard to say that they don't have much data about the crypto industry because it is a lawless industry. That's the word that's used. Okay. To which I think it might be replied, well, if you don't follow the Administrative Procedure Act when you promulgate rules, maybe you're a lawless agency. But That's really how you turn this around in these cases.
Mhm.
Isn't it? How do you, what is it you actually sue for? What claims do you make?
There's a number of claims that you could make, but just to finish on something that you mentioned, Pat, what's nice about the APA is it requires the agency both to give notice of what it's doing and to receive comment, and then it has to actually address
Yeah.
facts and arguments in those comments. So to the extent the agency says maybe in a proposal, well, we don't have the data, we don't know anything about this particular topic, you can introduce that in the rulemaking. You could confront the agency with your evidence, with your arguments, and if it's relevant to the rule and they don't address it, that is a classic ground to challenge it under the APA. So you could really try and force them to address what are real issues that they might otherwise not want to address.
Yeah, Chris has pointed out in his scholarship that this is one of the reasons why agencies eschew rulemaking when they can, because they have to give notice, they have to provide reasons, they have to comply with the APA. They don't need to do that when they sue people, right?
I will say that insight, I wish I was you know, that of any of the co-authors of Minor Right Code. This is actually, which is very interestingly enough, it was an insight from a former Democratic policymaker, you know, who was a very, very rational, sort of technocratic person. He says, well, you know, like there are different kinds of reasons why you do it. And you don't really, you know, it creates these very, very interesting questions as to, okay, well, you know, what are the incentives? And there's, you know, it's a spectrum. You can imagine why, you know, look, you have to do certain kinds of things to stamp out an emergency or to deal with an emergency, to deal with a problem immediately. And then there are, there may be some less savory incentives in some instances, right? As to, where maybe you know, transparency may not necessarily be viewed as optimal if you're the political actor in charge of carrying out the mandate for your agency. So it's really I'd love, you know, on the one hand, there's the how do you challenge the rulemaking question, you know, and to make sure that you get informed judgments and then the litigation. I'll say that there's one study that I did, and I was surprised a little bit that neither industry and I was very explicit, or the SEC had carried out, and we had actually canvassed with Broadridge. We'd sent out and we asked 1,000 people, I think, in the United States, 500 people in the UK, and 500 people in Canada, sort of prospective investors or current holders of cryptocurrencies. What do you think is important to know when holding a crypto asset, right? So you can think doctrinally why that could be important for definitions of materiality. It could be, what constitutes a reasonable investor, particularly in the crypto asset space. How it could be important from, revamping things over in Corp Fin for disclosure mandates and like. And the number of people who responded positively to this information and to this data, they were like, hey, this is great stuff. This is, obviously as a professor, you always want to hear that, but we were a little bit surprised that no one had ever done it, right? And from the standpoint of, again, making sure that the rulemaking is thoughtful, but as well as on the market end, from the industry standpoint, those kinds of checks to make sure that everyone is doing their homework is it's pretty important.
I'm getting questions from the audience about cases both defensive and offensive. I will say about the judiciary. Okay, I mean, do any of you have views you want to share about the knowledge of the federal judiciary about the crypto asset industry and how that might affect cases that are pending or threatened to be brought? Bill, you look like you might have a thought about that.
No, look, I think it's luck of the draw. I think people would be surprised at how sophisticated and how much some of the judges dig in.
Yeah.
Well, there's an enormous amount of discipline among district court judges. Look, I'm somebody who I still like to start my car by sticking a key in the hole. So the technology and the universe we're in today is so different. But these judges, you know, it's complicated. It's conceptually difficult for anybody who's over a certain age. But I have an enormous amount of confidence that most of the federal judges really roll their sleeves up and dig in. How they do it, given the workload and the compensation, I don't know, but they do it.
Yeah. Thanks. There's also a question about, what Congress might do in terms of defining key terms like crypto assets as securities. And rather than get into a discussion about that, because this is really about the agency, I'll just refer the audience to the FIT 21 Act that has been passed through the House and stopped there for now, and also the Lummis-Gillibrand bill on the Senate side, where these issues are treated with a lot of attention. And with that, I want to turn to Rachel Barnett, who's been patiently waiting. Thank you, Rachel. Rachel is a career general counsel and chief legal officer, first at an internet media company, then for Brooks Brothers, and then now currently she's chief legal officer of IEX Group, which operates the IEX Exchange and SEC registrant. Is also adjunct faculty at Columbia. So Rachel is, among other things, in a volunteer capacity, working on a steering committee with me and with Chris, for that matter, a private sector initiative, and there are several. We're trying to combine them, whose objective is to propose disclosure guidelines for digital assets, digital asset tokens that are offered in the United States. We can disagree about a lot of things, but I think we're all opposed to fraud, and we know that good disclosure is the antidote to fraud. Chris has done a lot of research in this area himself, and I think has some enterprising around it too. So he could well discuss this subject. But I'm going to ask Rachel, to please, describe, the goals, the objectives of this current private sector initiative, in which you have a role, but there are others, academics and practitioners playing a role. What are you trying to achieve? Plural.
Yeah, yes, thanks.
Yes.
Thanks for having me today. I first just want to echo what everyone has said so far. I think there needs to be an on-ramp. And if you are under enforcement, not for fraud, maybe for registration, I think there needs to come a time where there is a way to on-ramp. As I echo what you say in the beginning, when we started this, that it's not going away, right? This is $1 trillion market and it's not going away. But to start off in answering your question, I think it's helpful to understand the background and the problem that this working group, which was comprised of industry players, top academics, legal scholars, are all seeking to resolve. So to begin, the US financial markets are widely considered among the most dynamic and efficient in the world. In no small part, this strength is based on the role that robust disclosures play in furthering the protections of investors, maintaining fair and efficient markets, and facilitating capital formation. I think most agree, as you just started off by saying, that a standardized set of disclosures that reflect the unique and tailored characteristics of a particular digital asset and are therefore robust and informative would be beneficial to holders of these assets. This would provide regulatory clarity, and standardizing disclosures protects against information asymmetry. And I, for one, would appreciate having access to full and fair information for the tokens that I hold in my wallet. I think most would agree that receiving relevant disclosures would allow holders to evaluate the relative risks and merits of investing in such tokens. And there are companies like Masari that have been incredibly helpful in bringing information to the market. So why aren't investors receiving disclosures today? It's simple. the current forms are designed for different types of securities. From a regulatory perspective, the existing disclosure regime is applicable to equity securities, not digital assets. Digital assets is a different asset class. And the equity securities were created, the guidelines and the disclosures in those forms were created long before the advent of blockchain technology and development of blockchain-based tokens. Certain aspects of that regime may be confusing to issuers and investors. It may be difficult and impractical to apply to tokens. For example, describing the background of board members is not applicable when most token projects do not have a board of directors. Or asking for 3 years of past financial statements that relate to the financials of an operating corporation when the value of most tokens is not tied to the accounting financials of a company, but instead tailored based on the economics of an underlying network. In certain cases, it would actually be misleading to emphasize the financials of a token's development company over the economics of the token's underlying network. Similar to how, while not a perfect analogy, it would be misleading to value a third-party iPhone application based on Apple's financials. Most, if not all, token issues would struggle to complete the current forms, whether that's a Form 10, 10Ks, 10Qs, Form 1A. Some have tried, mostly after enforcement actions, and it did not end well for those tokens. The simple fact of the matter is that the current forms are not developed with blockchain-based digital assets in mind, and there needs to be guidance given so that the forms can be tailored and standardized for the new and evolving asset class. So to answer your question, that is the problem that the industry is seeking to solve. And a large group of industry participants, academics, law firm participants are coming together and compiling what would be meaningful disclosure guidance that could be standardized and tailored to this particular asset class. The focus was really to put pen to paper. It was to make the most meaningful types of information that a holder of a token would want to know, regardless of whether it's labeled as a commodity or security. This would include information regarding the underlying network, its incentive and reward mechanisms, the token's economics and governance, the risks associated with the network, and many items do not seem to fall neatly or clearly into the existing forms. Much of the debate has been focused on whether a token is a commodity or security, and that for sure is a threshold issue. But regardless of the classification, there needs to be disclosures that investors can rely upon in making informed investing decisions. And that is why this group came together. And I think if one reviews the Sidley and the Rutgers presentation, it's the Sidley and the Rutgers guidance that came out. That's what it's called, and can be found, and we can circulate to anyone who's looking for it. We ask that people review it and that they evaluate it. There's feedback that is still ongoing because it's most important for us as a community to come together and determine what is the most material information that needs to be disclosed to investors, and to put it in a digestible format so that investors can take that information and make informed decisions. In terms of more specifics, there are a number of places that you can look in order to get some sort of precedent in making disclosures. There were very few, as you mentioned, that filed disclosures. There was the Stacks token, the Props token, INX filed disclosures. Hester, Commissioner Pierce put out her safe harbor. There are MiCA disclosures. There are drafts of congressional bills, and there are other materials as well as multiple interviews of industry participants. All those can be evaluated to come forth with what could be one standardized disclosure for the digital asset regime. So what that group came together to do was to put pen to paper. And I guess I want to end with, this is not the first time that the United States was brought before it a security that was not an equity security. This is not the first time, right? Oh. There's plenty of precedent about what happens when you're in a situation where the forms don't necessarily fit the instrument. In the best precedent, there's probably two precedents that's come out that I recommend anyone on this call to take a look at. Is the first precedent was asset-backed securities.
Yes.
So when asset-backed securities came out, that in those circumstances, it was not an equity security. It was very similar to sort of, the problem of the disclosures with respect to digital assets, in the sense that they didn't have boards of directors. They didn't have like these, sort of operating financials. They didn't have GAAP accounting. 10Qs didn't really fit with them. And so it's an interesting analogy. And I will point out that there was a speech the chair made earlier on, where he too recognized the similarities between asset-backed securities that needed tailored forms and crypto. And I thought that that was a very keen way to look at things. And so in that particular case, how was it done? Well, the market came through with something called no action relief letters, allowing folks relief in order for them to put out standardized disclosures. And those letters were presented to CorpFin, and the Corporate Finance Department approved those letters, which then allowed an iterative process throughout the market to create standardized disclosures. And then ultimately, Reg AB was formalized in a more formal rulemaking process. So there is precedent for these types of disclosures. So ultimately, putting pen to paper is what this industry group is looking to solve for, creating what is the most material information for investors. And maybe one day these sort of guidelines will be helpful in creating what could be either a no action relief or a rulemaking process in the future.
That's very thoughtful and thorough. Thank you. The MiCA, which you referred to as, of course, the EU's protocol for crypto asset regulation. Chris probably knows more about that than I do. I'm sure he does. Chris, maybe I'll end with you the way we began. Are there lessons from the European experience that the SEC should ponder? This is a rare point in time where, in my view, in that Europe is actually ahead of the United States in the regulation.
Isn't that weird? I mean, that's, I mean, you know,
of an asset class, but that's because they actually decided to do it rather than just try to kill it.
yeah.
And you can't kill it because network effects take over, and pretty soon you have 52 Americans who hold these assets and 580 people around the globe, 580 million people around the globe. But are there lessons from Europe that the SEC should ponder and maybe act on in their program toward crypto assets?
So it's, you know, what you're saying is very, very timely, in part because some of the initial rules for stablecoins are kicking in on in just well, like literally next
any
week.
day now.
You know, I describe MiCA as being realistically, MiCA is a glass half empty and half full, and whereas the United States has no glass at all. Right. And I think that that's sort of the proper way of looking at it. It's a very ambitious set of rules designed to, amongst other things, like introduce transparency and disclosures into crypto asset markets. I'm literally knee deep in it. I started a new company called Blueprint, and we're actually helping to automate compliance with some of those rules with the Bank of Lithuania. We just finished our pilot last week. I think that the lessons to be learned include the fact that A, it can be done, B, it should be done. It's not an impossible task, as Rachel mentioned, to be able to identify some of the key, most important things that investors need to know, or holders of an asset need to know, in order to participate in a particular market. I think what's important is that there is a major market that's clearly identified the fact that there is a need for more tailored disclosures for this particular asset class, regardless as to, you know, whether or not you like it, you don't like it. At the end of the day, the regulatory regime should speak to the actual characteristics of the financial market that it's seeking to supervise, and especially when it comes to information, especially where you're dealing with an asset class that is more technically complicated, and so therefore one would normally expect more of an emphasis to try to demystify the important parts of information and data, and to organize that information in a way that people can act upon. I think the lesson is it can be done, it should be done, it will be done eventually. Whether or not the United States comes to the party last and ultimately opts into a set of global rules that other people are starting to develop is one question. I think that it is an iterative process. I was around as a baby lawyer during the European Prospectus Directive, and that process where they were trying to sort of take on different kinds of material and infrastructure that looked more like the United States. You know, there will be a MiCA 2, there will be a MiCA 3, just like there's a MiFID 1 and a MiFID 2 and a MiFID 3. But it is a process, and at the end of the day, the regulators are going to have to engage and embark on that process. And that it is not a matter of being a sop to industry to write those rules. Instead, it's a core aspect, a core part of the mission of any regulatory agency, which is to write rules for stuff and to figure out exactly, you know, how to regulate something in an efficient and informed way. Again, the process in the European Union is not perfect. They're not going to be able, you know, there are lots of question marks that are still outstanding, and they're going to, you know, go through the process in a way that people are not always going to be happy with, because it won't always be as organized, frankly, as it could or perhaps even should have been. But again, you're dealing with 27 different member states and countries involved in a process, as opposed to 50 US states. So it's something to keep your eye out on. Like you, I've never before seen US politicians decamping for Brussels to learn stuff. Like it's usually the other way around. But it is a sort of feather in the cap of the EU that they have sort of started that process.
Well, I hope we catch up actually, and and reassert leadership. These are as Chairman Chad used to say, you know, the deepest capital markets in the world, and it's important that they be regulated correctly. We could go on forever, but I want to keep to my promise to hold this just to barely more than an hour. So I'm going to turn it over to our friends from the Federalist Society to wrap up the show.
Great. Well, thank you, Pat. On behalf of the Federalist Society, I want to thank our panelists and our moderator for the benefit of their time and expertise today. Thank you also to our 100+ audience members who joined us. We greatly appreciate your participation. Check out our website, fedsoc.org, or follow us on all major social media platforms at FedSoc to stay up to date with announcements and upcoming seminars. Thank you once more for tuning in, and with that, we are adjourned.